My name is Jay Chauhan. I am a lawyer in Richmond Hill for over 40 years' time. I am a retired deputy judge. I'm a lawyer also in 3 different jurisdictions. And my topic for today is the self-represented litigant and the limited engagement retainer. And what are they? And how does it affect our legal practice in the Ontario Society where we practice as well? So this will be uploaded in the Angel Mentorship Group, and anybody is invited to join. Most of the members are lawyers and paralegals, and the numbers are increasing, and we welcome you to join our group. So today I want to explain the slight historical background to how the concept of the representation of the barrister rose in the English history, and that we adopted in Ontario in about 1867 through the British North America Act enacted by the British Parliament, which was then applicable in Ontario. All the lock, stock, and barrel, the procedures and the method in which the barrister solved the problem and represented the client comes from the English law. And here we have a fused profession in Ontario where the barrister and solicitor both are joined as one profession, whereas in England it's different. There in England, the solicitor acts in terms of the client relationship and the barrister goes to court. Here we do both. So when you represent a client, you're taking responsibility for what you do in terms of the knowledge of the law, with the duty of care, and the threshold of negligence in which we are making sure that we advise the client correctly. And then we also observe the rules of professional conduct, which are designed around the barrister's conduct with the client in the courtroom and in the relationship with the client as well. But there in England, it would be more the solicitor dealing with the client, and here is the lawyer, broadly speaking, who is conducting himself in the relationship with the client. So firstly, when you represent yourself, it becomes the self-represented litigant. It means you are, as a person engaged in a conflict, in a legal situation, going on your own to the court. That is, you representing yourself. There is in the recent history a dramatic rise in the number of court actions that end up in the courtroom where judges have to deal directly with the litigants who come before them without the knowledge and the background of the academic law that the lawyers learned for many years in the courtroom. So I think the judges are more sensitive. In my practice, in my role as a judge, which I'm now retired in that capacity, but I had to deal with a large number of situations, and especially in the small claims court, where I would say almost half the number of people who appear before you are regular citizens. They are engaged in litigation without any lawyer, and they figure it out from a lot of support you can get on the internet today. So when you represent yourself, you are a self-represented litigant. Now that's the definition of who that is a person going in the courtroom on his own. Now, what is the requirement of the lawyer in such situations is something very interesting. It has recently been changed by the Law Society. So now we have the limited scope retainer that is permissible. It was always, in my opinion, always possible, but the clarity of the professional rule of conduct was not enunciated clearly in the language of the professional rules of conduct as it is now. So if you review the wording, what is it that you should do is essentially that you have to clarify to the client that you are only supporting the client or advising him in a limited situation. For example, you are drafting a claim for him, and then you're no longer responsible as to what happens in that matter. Suppose you represent the client in just a hearing, let's say motion, and then you have to advise the client and of course the court that you're only acting in that particular situation, and the clarity of what you say in the limited engagement retainer, as I call it, you have to be very clear to the client. So how does the two arrangements work out in this situation today? In my view, there is a rise in the number of people who are going to the court on their own. And it's very important, in my view, that we as lawyers and paralegals support the community to resolve the disputes which are of legal nature in a fashion that is reasonably possible in the budget of the client. The lawyers, in my opinion, have, because of their legal background, they're similar to doctors' education, they charge in the range of $250, $300, $400 an hour, and I charge $450 an hour with my number of years of experience, but that is very common. But does that make it possible for a client to afford your services when the time comes? So it's very important that we are providing a supportive arrangement to the client when it comes to the client's inability to pay for a typical case in the courtroom. A typical case, in my view, that starts from the statement of claim to the trial for an action, even a $50,000 action, can end up costing $20,000, $30,000 very easily. So it is very important that when you are a lawyer or paralegal, you're mindful of the fact that it is not possible for everybody to be able to have a lawyer or even a paralegal. And I think this is why the profession of paralegals has arisen. And I think, in my opinion, it's a good thing that has happened. And whenever we can, and if we cannot represent the client with our name on the record, we should be willing to help the client to carry out a particular procedure to help him to prepare for the documents and the hearings so that he can do the rest on his own. So I hope that was helpful. Hope you join the group, Angel Mentorship Group. If you like the video, please make a notation and your comment below. Thank you.